this webinar series. We started in January by looking at the ILO system to even understand what is the ILO and how these conventions are established.
Hello, Mustafa. We seem to have lost you.
Hello, show.
Apologies, there was a technical glitch there. So we started the series in January, looking at the ILO system, understanding what the ILO is about and how these conventions are established. We then moved on in February to the second in the series, where we looked at the conventions on forced labor and underaged workers. In March, we looked at the Convention on Freedom of Association amongst trade unions. And here we are today looking at, or with the plan to look at the conventions on discrimination and pay disparities. And so we have an eminent panel, and the moderator will be introducing them. And the moderator is Mr. Nonso Azi, who is a practitioner in employment and labor law, and also who does quite a bit of other aspects of law, but he's primarily known for his work in employment and labor law. And so I'll hand it over to the moderator, Mr. Azi, to introduce the eminent panelists, and we take it from there. Mr. Azi, over to you.
Okay, thank you, Shehu, for that introduction. And good afternoon, ladies and gentlemen. My name is Nonso Azi. Without further ado, we would like to introduce our speakers, whom we can describe as high-powered delegation. So we have our lead speaker, Tama Gabisonia. And Tama Gabisonia is a lawyer and the International Lawyers Assisting Workers Network, regional coordinator for Europe and Central Asia. Since 2019, he has been an invited lecturer, and she teaches labor law in the European University. Tama graduated from Tbilisi State University with a law degree. In 2015, she obtained a master's degree in international human rights law from University of Essex, the United Kingdom. She works for Georgian Trade Unions Confederation as a lawyer. She is a member of Georgian Bar Association and recently has been appointed as a chairperson of the GBA Labor Rights Committee. Over the past 15 years, Tama has been working on human rights issues. She worked for Georgian NGO Article 42 of the Constitution as an executive director, human rights lawyer, trainer, project manager, and researcher. In 2014, she was elected as a chairperson. She was elected as a chairperson of Human Rights House in Tbilisi. Some of her accomplishments include being invited as a human rights expert in different organizations. In 2015 to 2020, Tama worked as a lawyer for Georgian Confederation. From 2020, I've been working for the U.S. Solidarity Center as a regional coordinator of the International Lawyers Assisting Workers Network for Europe and Central Asia. Tama has participated in various human rights programs in different countries. She has an experience to work for international NGOs in the UK and US. She has experience litigating cases before the European Court of Human Rights. She's co-author of brochures and has done researches relating to the various human rights issues. She is a certified trainer on anti-discrimination issues and European Social Charter, and has provided trainings on different human rights topics. Ladies and gentlemen, that's a short biography or profile of our lead speaker, Tamar Gabisonia. And then we have Monica Tepfer, who is a lawyer and graduated from the University of Buenos Aires, UBA, and holds a master in public policy from Tucato de Tella University in Argentina. Currently, she works as a legal officer of the International Trade Union Confederation, ITUC, based in Brussels. Previously, she worked for more than 10 years as a legal advisor at the Secretariat of International Relations of the General Confederation of Labor of the Argentine Republic, CGTRA, trade union, where she was training specialist with extensive experience working with TUCA, Trade Union Confederation of Workers of the Americas, and ACTRAV, Office of the Workers' Activities at the ILO International Training Center. She's an author of several articles and reports on labor rights, addressing topics such as algorithms, artificial intelligence, and platform economy. She's been a speaker at regional and international events on freedom of association, collective bargaining, and labor rights. And we also have our very own distinguished senior advocate of Nigeria and a partner at one of the leading law firms in Lagos, in Nigeria, actually, Mr. Inam Wilson, senior advocate of Nigeria, who heads the investigations, white collar and compliance, and the labor and employment, as well as the transportation practice in Templars. He holds a Master's of Law, LLM, degree in Maritime and Commercial Law from the Lagos State University, Lagos, Nigeria, and he's a notary public. For Nigeria. Mr. Wilson regularly competition and trust areas. INAM also advises generally on regulatory compliance, and also serves as independent investigator. He has handled very complex corporate internal investigations on compliance issues arising in a wide range of sectors. Mr. Wilson is overly familiar with recent global labor and employment trends. He's one of the leading lawyers practicing actively in the National Industrial Court of Nigeria, and he has, through his seminal submissions in court, contributed immensely to the evolution of labor jurisprudence in Nigeria. Mr. Wilson has presented a litany of seminal papers, written a plethora of articles, and co-authored books in diverse areas of the law, with emphasis on white-collar crime, labor and employment, shipping and maritime, oil and gas, and others. And last, but by no means least, is our very own Ademayowa Ogunmola, who is a very active member of Airland, Nigeria. She has cognate experience in investment management and finance. She is a skilled corporate and commercial legal practitioner with over 13 years post-call experience in various industries, including construction, telecommunications, real estate, manufacturing, and commercial litigation. She also provides advice on business, corporate commercial practice, general litigation, and intellectual property. Mayowa is based in Nigeria and is currently the Executive Director, Corporate and Legal and Regulatory Services at DPL Construction Limited, She brings her experience from previous roles at Cloud Limited, Jotna, Nigeria, Lagos, and Ibadan. Ladies and gentlemen, you can agree with me that we have an assortment of fantastic, well-experienced speakers. This juncture, may I humbly invite Tama Gabisonia, who is our lead speaker, to make her key presentation. Tama, over to you. Thank you very much.
Thank you. Thank you, everyone. Thank you for having me, first of all. And I'm really glad to have an opportunity to share my experience and regional experience on implementing convention, Law Convention 100 and 111 on discrimination. Let me start with sharing the presentation. I think that I need the access to share the screen. Sorry. By the host. The permission to share the screen.
Okay, the admin will do that right away. Yes. Thank you.
Okay.
Okay.
Okay, thank you. So
yes.
Here we go. So you see the screen, right? Okay, so let me start because I do know that we're limited on time, and I will try to deliver the information, the knowledge and experience that I have. And we're of course concentrating now on ILO Convention 100 and 111 on equal pay for the work of equal value and prohibition of discrimination in employment and occupation. Of course, so when we speak on the convention, so it is important to stress an emphasis on the aim, of course, and the standards that the International Labour Organization, ILO, sets for all conventions. So it brings member states to promote the application to all workers of principle of non-discrimination and equal pay for the work of equal value for men and women in employment and occupation. It is, of course, important that the ILO conventions, both 100 and 111, there are core conventions. And as you know, there are 200 conventions that ILO delivered, but 9 conventions out of them, it's fundamental conventions, and both of the 100 and 111 conventions, they're both core conventions. And a lot of countries in the world, of course, ratified the conventions, and the conventions became the part of the, I would say, the national legislation in a lot of countries. So it has it has universal coverage, which means that it covers the whole world, including the, of course, the African region, European region, and US and Latin America, Asia, and globally. It has a global coverage, and it applies to all workers. And also what is important in my point of view, so there is no activities or economic sectors that are excluded, I'm sorry, from the coverage of the ILO conventions. So, but what I would like to stress and emphasize that there is, of course, the conventions. Before I'll go through the main regulations of the conventions and the following recommendations. So I'd like to emphasize that there is a need to develop the supervisory mechanisms in each and every international organization to actually function the conventions efficiently. And of course, International Labour Organization has created long ago the supervisory mechanism that actually monitors the progress of member states in the application of international standards, including the conventions that we talk today. So member states, what it brings, the supervisory mechanisms and how it monitors the progress of implementation of the convention. So member states are obliged to submit newly adopted standards to national legislation and have the obligation to report periodically on the measures taken to give an effect to the provisions of ILO conventions and recommendations, and how it is done actually I would say mainly into different ways. It's the periodic reportings that states are obliged to provide to the International Labour Organization, and there are also the special procedures based on representation or complaints to the governing body made by ILO constituents. So what's the important with this role is that the periodic report, under the periodic report, so countries, member states provide their point of view, how they implement at national level the conventions, but civil society has the possibility to actually provide their point of view on the view that the member state gave to the ILO. So then the committee of experts in the ILO has the holistic kind of comprehensive picture what happens in the country from the point of view of the state officials and the point of view of the unions or civil society organizations, and then they deliver the recommendations according to which each and every country needs to follow for the next reporting period. That gives on the one hand the ILO supervisory mechanism to have updated information, and the other hand the states are obliged to make some changes to respond to the questions and to actually implement the recommendation that comes from the ILO supervisory mechanism, from the experts' recommendations. So, most importantly, it is very, very important how the countries, how the member states handle the issue with the efficient and effective implementation of the conventions. Let me talk a little bit about the standards. Of course, the ILO sets the standards, and when we talk about the non-discrimination provisions, especially when it comes with gender discrimination issue, C100, it's Convention 100 is one of the core conventions that actually sets the standards to guarantee equality of opportunity and treatment in access to employment, training, promotion, organization, and decision making. And it protects women workers, especially in relation to terms and conditions of work, occupational health and safety, and in relation on maternity-related issues. So, but of course, conventions give some kind of principles and declarations and the regulations that really needs to be implemented in the country, but it is followed by the recommendations, which is also very important to consider. And it gives the more of the explanation how efficiently the regulations and the provisions of the convention can be properly implemented in these or those countries. So recommendation number 19 is the recommendation that follows the Convention C100, and it sets the standards to ensure that employers and workers are fully informed about the legal requirements. They need the provisions of equal facilities for both sexes, for vocational guidance and trainings for placement to increase the efficiency of women. It's also important the provisions of welfare and social services to meet women's needs, the promotion equality of men and women workers in access to jobs, which is one of the important core issues in almost in a lot of countries, and promotions of public understanding of principles of equality and research and studies in the field. After, so we can see how the ILO supervisory mechanism and how states can actually try to implement those standards in various countries. Now let me turn to the recommendation, to the convention, to the standards that Convention 111 sets. for the member states. It promotes equality, of course, of opportunities and treatments in employment and occupation, and it prohibits discrimination in employment and occupation. Requires adoption of national policies, and we'll see later on how it is implemented in various countries on country examples that I tried to select for you. And where is the gaps and what is the challenges and what's the best practices. So requires adoption of national policy on equality of opportunity and treatment in employment and occupation. It also requires repealing and revising of any laws and changing any administrative instructions or practices which are not in line with the policy, and provides for consultations by government with the social partners, of course, with workers' representatives and employers' representatives to promote the objectives that comes out of the conventions. So, and we can say that both conventions provide a framework for government, employers, workers, and other stakeholders to work together to create environments where everyone has equal opportunities and fair treatment in employment. Now, so let me see, we've talked so that the member states are obliged to set the standards to effectively implement it. And I wanted to, since I cover, it was mentioned that I am representing International Lawyers Assisting Workers Network, ILO Network, so, and I cover Europe and Central Asia, and I tried to select countries under my coverage and to actually share my experience, what we have done in the region in this regard. So we have members, we have this big, huge network with global network with 12K lawyers, and I would say that African region is really, really very active, and I'm really proud that we have the opportunity to share experiences with each other, and we already had this practice to bring together lawyers from different regions to talk about the various issues that help them to promote workers' rights at national level. So, and so what we have done, it's, as I said, the government provides its report, periodic report, and submits the report to the ILO. But we've helped our allies in Georgia and Armenia to deliver alternative report to the, in one case, ILO, International Labor Organizations, in Georgia's case, and in Armenia's case, it was women's rights related issue, but we submitted alternative report because it was the timing to submit the report to the CEDAW committee. So on women's employment, related to the specifically women's employment, occupation, and what's the issue with the implementation of 100 and 111 conventions in relation of women's rights. So, and that helped us to bring our voice to the international organizations, and then they benefited out of it because they had more holistic picture, comprehensive information, what has been done by the country, what the challenges that still remains unchanged and still needs to be addressed, and what's the recommendations for future improvements. So let me focus on, I've selected, like, I made the geographical selection as well as the selection by the criticality of the and the challenges that country face. So I selected my own country. So I am from Georgia. It's a small country in Europe, not the US Georgia, which is a bit confusing. So for some people, but I've selected Armenia, which is also Eastern European country. I've selected Western European country, France, and Also, since I cover Central Asian region, so Tajikistan is the country that is in Central Asia, and I wanted to show you the examples of Central Asia too, and what's the similarities, what's the differences, and how we tackle with the issue. I do know. Please let me know about the timing because I can talk about this endlessly. I am trying to keep myself on time, but let me know if I go to kind of I will use too much time. So when we talk,
if you can summarize in 5 minutes, how will be
5
grateful.
more minutes. Okay,
Yes.
okay. So when it comes with the Georgia, I would say that there was a big discussions during law amendments in the country. So in 2019 and 2020, a lot of changes in the legislation has been implemented. But there's still a lot of gap that needs to be filled. For example, the country declared the principle of equal remuneration, equal pay for men and women for work of equal value, but there is no methodology how to measure what's the equal value. So, and the simply declaration made, it's not as important because it needs to be addressed and it needs to be to the methodology how to measure the work of equal value. That's why ILO committee, supervisory body, expert committee, they of course stress and emphasize the good practices that law amendments that defined what's the indirect and direct discrimination, and also of course harassment issue has been improved in the Georgian legislation. A lot of gender sensitive provisions were added, but still there is a lot of efforts that needs to be made to train and raise awareness toward the public, and also government has been asked to provide the information about the complaint procedures available for workers when they are where their rights are violated, and the government has been requested to provide the information of any studies or information gathered on the practicability and acceptability of substantive and procedural provisions which allow claims to be brought. And I would say that in relation to the C111, it also refers to the specific bodies that can consider the complex, can study the case. It's the judicial system, of course. It's the public defender's office in Georgia, of course, and it's the labor inspection service in Georgia. So, and the ILO experts asked the countries how to provide the information about the number of the cases to be handled by these organizations, by these institutions, and to measure the success of their work. So that's about Georgia. Let me turn to Armenia, which we have also worked. They had recently amended labor code as well, and there were some provisions, gender-sensitive provisions, included in the legislation. But still, committee asks the government to take the necessary steps to give full legislative expression and effect to the principle of equal remuneration for men and women for work of equal value. And of course, asks for the evaluation criteria, qualifications, skills, and responsibilities, efforts, and conditions of work to ensure that men and women have a possibility to get remuneration for work of equal value. And as for C111, it urges the government to make some changes in the labor legislation and to provide information of any progress made in this regard, to strengthen the legislation provisions related to the sexual harassment in workplace, and indicates that to provide the information, any practical measures taken to address hostile environment and harassment, including through awareness raising. There are a lot of issues about the awareness raising because it's kind of one of the very important issues, because there is important that there are provisions, but it needs to be kind of spread toward public and workers to have the ability to actually use this opportunity, use the bodies, institutions to file the complaint and so on and so forth. I selected France, so you all know that France is the Western European country. It looks like they faced less problems with the implementation of minimum standards because they try to keep the high standards. And when Eastern European country, we try to amend the legislation, we always rely on the Western European countries as an example to promote the workers' rights protection. But it's interesting that some of the provisions, some of the challenges that even France face, it's the similar as, for example, Georgia, Tajikistan, and Armenia face. So one of them is like that the committee asked the government to continue taking measures to evaluate and analyze gender pay gap, because gender pay gap is one of the main issues in France too. And in with Convention 111, so committee urges the government to combat horizontal and vertical occupational segregation and promote gender balance in jobs at all levels. And it's also that tries to identify and eliminate obstacles to equality and women's employment. And of course, the gender stereotypes, which is an issue in sexist prejudice, which is an issue in France too. So. And let me lastly mention the Tajikistan. Last but of course not least, very important recommendation has been delivered toward Tajikistan too, when committee asked the government to step up its effort to pursue its action toward the elimination of the gender pay gap in all sectors of a common economy, and it's particularly addressing the male-dominated sectors, and to continue to address the underlying causes it has identified. So we can see that there are also the recommendations that lays on C111. So I can share the presentation with our group of people, participants. So you can see in details about the recommendations that the ILO committee delivered. But I just want to use 1 more minute from my presentation to actually see what we as a civil society organizations, workers' rights defendants can do in order to promote workers' rights in worldwide. So it's the advocacy work that we do a lot. So under the advocacy work, I mean alternative reporting that we do under the ILO network. We help our allies and partners to develop the report that covers each and every important aspects of the implementation of the conventions. Strategic litigation. So under strategic litigation, we mean the cases that is important strategically, and the results on one case can affect positively on hundreds on others, or can result initiation of the amendments in the legislation or in the practice. That's the strategic case, and through strategic litigation, we try to address workers' rights protection, which is one of very important tools, and of course, improving the legislation and providing and improving the wrong practice and establishing best practice at national level as well as international level. Awareness raising and media campaigns is the part that we can, as a civil society, we can be responsible for. So awareness raising is very important, and media campaigns is a very good tool to use to deliver messages, right messages to workers, to lawyers, workers' rights lawyers, of course. And lastly, networking. So sharing experiences and learning from each other's challenges, and of course, implementing the best practices in our work, for our countries, or for regional work and global work, it is really, really important. And our collaboration now is one of the kind of example of using this tool as an advocacy tool to promote workers' rights. Thank you for your time, and thanks for having me. So I'm here.
Thank you. Thank you very much, Tamar. I mean, it's very clear that if we give you more time, you could speak on this passionate topic, which is very dear to your heart, for the next few hours. Thank you very much. You've taken us on a tour of these critical ILO conventions. We'll get back to you and take up some of the issues that you have raised. But now let's bring it down to our jurisdiction, Nigeria, and that will take us to ask Mr. Inam Wilson, Senior Advocate of Nigeria and a leading employment and labor law practitioner who have litigated matters at the National Industrial Court and other related matters at other courts. So, Mr. Wilson, I would like to ask you, what would you say is the scope of the National Industrial Court of Nigeria, which is a specialized court for labor and employment in Nigeria? What would you say is the NICN's powers and jurisdiction as it relates to these ILO conventions, C100 and C111? Can you briefly share your thoughts on this? Thank you, sir.
Thank you very much, and good afternoon, everyone, again. And thank you, Tama, for that very rich and resourceful presentation. Just listening to you, I was listening to you with all admiration at the extent of work that is going on in some other parts of the world. And I'm asking myself, how far are we from the rest of the world, those of us in Nigeria? Anyway, let me try to attend to the question. To be able to attend this question, it's good to just give a bit of context. Nigeria was under the military regime for several decades. And so if you locate the years of the conventions, the two conventions, the Equal Remuneration Convention 1951, and which we ratified in 1974. In 1974, Nigeria was under a military regime, and therefore the environment was not too conducive to be talking about equality of rights and fundamental rights, as it were. If you take also the Discrimination, Employment and Occupation Convention, C111, it was also passed in 1958 when Nigeria was not even an independent nation, right? But it was ratified in 2002, and without holding brief for the government, I would say that it's probably because the country was also under military regime up until 1999. So if we are looking at the scope of the NIC's, the National Industrial Court's jurisdiction in respect to the two conventions, we have to bear this in mind, which means that it's probably from 1999 that we started talking about seriously ratifying these conventions. So as at 1999, the operative law was the Constitution of Nigeria, which came into force in 1999. And incidentally, unfortunately, the Constitution itself did not make specific provisions relating to these two rights, but Section 42 of the Constitution guaranteed certain rights. And these rights are rights from guarantees to Nigerians, freedom from different forms of discrimination. Could be ethnic, could be place of origin, could be sex, religion, or political opinion, but definitely nothing to do with work, wage, employment, and the rest. But nevertheless, a lot of the cases that I was involved in, and I was privy to, under the regime of the 1999 Constitution were based on this Section 42. And then fortunately for us also, the African Charter on Human and People's Rights was ratified and domesticated. So those were the twin pillars under which these rights were enforced in Nigeria. Then in 2006, the National Industrial Court Act was passed into law, and it established the National Industrial Court, but this law itself did not make any specific provision relating to wages, discrimination, equal pay, and all of that. it wasn't until the third alteration to the 1999 Constitution, which came in 2010, that Nigeria seriously started addressing the issue. Sections 254C, 1, F, G, and H, as well as subsection 2, now made extensive provisions in relation to what we are talking about. And if you just permit me, I'll just highlight them. So these sections granted the National Industrial Court jurisdiction to deal with any matter relating to or connected to unfair labor practices, international best practices in labor, employment, and industrial relations. And some of the decisions that have come out of the National Industrial Court has been to the fact that international conventions, treaties, and protocols are indicative of international best practices. And therefore, there is the tendency and inclination by the National Industrial Court to apply some conventions and treaties. Then also, the Industrial Court, National Industrial Court, has jurisdiction to deal with any matter relating to any dispute arising from discrimination or sexual harassment at work. As we'll come to find out in the course of this presentation, discrimination or sexual harassment in the place of work is a form, has been held by the National Industrial Court to be a form of discrimination. Then most importantly, if I may say, the National Industrial Court now has jurisdiction in the application and interpretation of international labor standards. Then subsection 2 grants exclusive jurisdiction to the court in the application of any international convention, treaty, or protocol ratified by Nigeria relating to labor, employment, workplace industrial relations, or matters connected thereto. And so you find that a lot of the decisions that have come outside of the National Industrial Court, which has tried to, the judiciary has tried to implement C100 and C111 through judicial pronouncements, have been on the basis of the third alteration to the 1999 Constitution. I think I'll stop there for now, and we'll expand on this in the course of this presentation. Thank you.
Thank you very much, Leonard Silk. This is just a tip of the iceberg, because we know the stuff of which you have made. And thank you for this teaser. And I know that the audience will be itching, maybe to raise their questions in due course, because you've actually struck a chord that resonates across board as regards the enforcement of these rights in Nigeria. So I will go over to Monica, who had extensive experience in this subject matter, to hear what she has to tell us about, how Convention 100, C100, has been able to address the principle of equal remuneration, for work of equal value. And I mean, is this concept, is it also applicable in digital economy? If you could quickly tell us how C100 addresses the principle of equal pay, equal remuneration for work of equal value, and just highlight on whether this concept could be applied to the digital economy as we have come to know it in the modern world. Thank you very much.
Thank you. Thank you so much. First, thank you for inviting me to participate. Good afternoon, good morning to everyone. Well, I'm Monica Tepfer. I am from Argentina, but I work for the I2C, the International Trade Union Confederation, here based in Brussels. And I'm really happy to share with you, of course, our view in terms of equal pay for equal value, which is a fundamental right. It's a fundamental human right. But also, I think I would like to also take the opportunity to not only to address and explain a bit more at which extent these principles also apply to digital economy, but also highlight two key aspects that are really, really important, and maybe at the end of the webinar, if we still have time, I can go deep on that. So first, also to let you know that this year, the International Labour Conference in June will have a general discussion on care economy, decent work and the care economy. And for sure, this principle, equal pay for equal value, of course, it's an essential part of care economy. It's an essential part of guarantee decent work for care workers. So, I mean, this is a very, very important topic that probably will also be part of the general discussion, and we will probably see further conclusion from the ILO in this regard. But also, and it's quite important to highlight as well, is that next year, we will have a standard setting on platform economy. A standard setting on decent work in the platform economy means that we may have a new convention, also recommendation, on platform economy, on how we regulate working conditions for platform workers. And one of the key aspects, and I will explain further later on, is also equality and guarantee equal opportunities for platform workers as well in between them, but also gender equality in the digital economy. So this webinar is excellent in that regard because it addresses two topics that are crucial, because not only we are talking about human rights, it's also that is part of the agenda at international level. So in 1 month, we will discuss care economy, which also address discrimination in employment relation, which this is also part of the principle of equal pay for equal value, but also is also part of our strategy on the discussion for next year on platform economy. So by saying that, I would like to briefly, because Tamara has done an amazing explanation on the main concept of Convention 100, but I would like to address a little bit a couple of things before going directly to how we can implement the principle of equal remuneration for equal work of equal value, and also, I mean, the definition, what that really means, right? And I would also like to take the opportunity to explain about the workers' perspective on this regard, how unions have a key role to play in order to address this principle. So not only mention about the convention, but also on the role of the trade unions in this sense. So to close, the goal to close gender pay gap is set out at the ILO Constitution. Of course, also is set out in the Convention 100 and 111, as Tamar recently explained perfectly well. But also the Declaration on Fundamental Principles and Rights at Work declare equal pay a fundamental principle to be promoted, respected, and realized by all ILO member states. Most recently, also, the importance of achieving equal pay for women and men for equal value work was reflected in the ILO Centenary Declaration, but also was reflected at the global call to action for a human-centered recovery from the COVID crisis in 2021, which reiterates the importance of public policies and enterprise practices as well to ensure equal pay for equal value, supported inter alia by pay transparency. The resolution concerning inequalities and the world of work, the ILO resolution from 2021, further underlines that measures for equal pay for work of equal value and pay transparency, among other measures, including in supply chain, are key for fair distribution of the fruit of economic progress. So I highlight this because I think that when we address these principles, we need to be clear and understand the legal framework that are behind that principle. So what does the convention state? And I will not go in deep because Tamar has done an excellent explanation, but yes, I want to put the focus on the definition, right? On the definition of this principle. But for that, we need to understand what remuneration means, what value means, right? So the Convention 100 define remuneration that include the ordinary, basic, or minimum wage or salary and any additional emoluments whatsoever payable, directly or indirectly, whether in cash or in kind by the employer to the worker and arising out of the worker's employment. This broad definition makes it clear that all elements in addition to the ordinary, basic, or minimum wage or salary should be considered as part of the remuneration for the purpose of this convention. But also indicates that equal remuneration for men and women workers for equal value refers to rates of remuneration established without discrimination based on sex. It requires member states to promote and ensure the application to all workers of the principle of equal remuneration for men and women workers for work of equal value, and refers to this by means appropriate to the methods in operation for determining rates of remuneration, provides that the principle may be applied by means of one or more of the following: national law regulation, legally established or recognized machinery for wage determination, or collective agreements. So I will stop here just to briefly say something and then we will continue. So what does it mean? It means that first, we have a definition on remuneration in this convention, which is a fundamental convention and applies to all workers, including also workers in the digital economy. So here, the first link we can do with the first question. But also establish that by doing that, it means that governments, by applying this provision, the means available for them are legislation. It means that they need to set up legislation. Tamar was explaining the fundamental role of the ILO supervisory system, in which they provide technical guidance to governments on how they can set the national legislation in accordance with this convention. And you can perfectly see, I was reading carefully comments on the ILO experts on how they recommend governments to set up national framework in line with this principle, but also highlight the key role of established mechanism for wage settings and collective agreements. So here we have three means of action that for sure include the role of the workers' organization. In establishing a national framework, perfectly well for us, for workers, because we can do it through social dialogue at national level. So we can participate in the debates, we can provide our inputs in the debates before the Congress adopts any legislation. Wage determination, of course, machinery for that, we can be part of the table for that. And collective agreements, for sure, this is something that is actually collective agreements in terms of wage, in terms of equal pay, is one of the key issues that trade unions can perfectly well handle with employers as well during the negotiation table. So one of the aspects that was promoted by this convention, and Tamar mentioned also, is that the convention promotes the objective on job evaluation. Why? Because actually, and this is very interesting to understand as well, that job evaluation means, because the definition of equal pay for work of equal value, it doesn't mean that we have to receive all of us the same salary. It means that it can be also different type of jobs, but the value, it's the same. So it means that they have the right to receive the same salary, the same pay. So for that, the process of job evaluation are key. And not only we will find good provision on that on the convention, but also the recommendation 90 has a specific guidance on that regards, which I do believe that are crucial for that. So by saying that, I would like to go a little more in deep, if I still have time, to discuss more about this concept, and then we will highlight the importance of applying this concept in digital economy. So as I was saying, the concept of work of equal value includes but goes beyond equal work. Equal pay for equal work means that similarly qualified women and men will be paid equally when they perform the same or virtually the same work in equivalent condition. This is an important distinction, and it means in plain language that women are not only paid less for the same job as men, but the jobs that are disproportionately female, such as those in feminized sectors, are often valued less. This means that jobs can be different, but still be considered to be of equal value when the educational, professional, and training requirements are in reality equivalent. In such case, both jobs should receive the same pay. This is challenging, as detecting unequal pay for work of equal value is not straightforward. It requires a careful job evaluation that applies objective and common criteria such as relevant skills, education, relevant work experience, and working conditions. And as I say, this is set out in the ILO Convention 100, and more information we can find it in Recommendation 9, which actually emphasize the importance of the social partner in the context of job evaluation, and provide that members should, in agreement with employers and working organizations, establish or encourage job evaluation methods. One of the reasons why so little progress has been achieved with regard to respecting the fundamental right to pay equity is highlighted actually by the ILO Committee of Experts. The ILO Committee of Experts notes that the difficulties in applying the convention in law and in practice result in particular from a lack of understanding of the scope and implication of the concept of work of equal value. This concept is a cornerstone of the convention and lies at the heart of the fundamental right of equal remuneration for men and women for work of equal value and the promotion of equality. So assessing the value and corresponding requirements of different jobs on the basis of common and objective criteria also contribute to a more transparent and efficient system for pay determination.
Thank you.
Let's continue. If I still have 5 minutes more, it's possible?
Oh, okay. Let's just maybe
only 5 minutes more, because I want to discuss something that is important in terms of the digital economy. Yes,
all right.
Through digitalization at the workplace, artificial intelligence can also provide an opportunity. But nevertheless, the recent developments in the digital economy may just as well perpetuate gender gaps. For instance, artificial intelligence using algorithms for job machine may lead to discriminatory outcomes from women, such as generally showing them job offers with low pay. There is also a risk that automated applicant selection is based on characteristics that are proxies for gender. This is why also we have to recall that the ILO Declaration, this ILO-centered declaration, calls on member states to promote, sustain inclusive and sustainable economic growth, full and productive employment and decent work for all, and to respond and measures that respond to challenge and opportunities in the world of work regarding the digital transformation of work, including platform workers. So for sure, this is a principle that applies to the digital economy. We have a new challenge. We have the algorithm management that are nowadays framework their worker relation also, and this is also important to keep in mind. And thank you so much. I will be here to continue the discussion. Thank you.
Yeah, thank you very much, Monica. I mean, you've really drawn some fine distinctions on this concept, because they may appear to be simple, but in practice and in application, what we take away from your presentation is that you've been able to draw the details and these fine distinctions, so that when we hear this concept and when we seek to apply it, in this jurisdiction or wherever we may find ourselves, we can actually understand, what they mean as regards all manner of discrimination, whether by gender or on any other platform. So we will get back to you. Maybe you have some more light to throw on the issue. So I will quickly go to Mayowa, and that will be against the backdrop that the last time I checked, I think I checked NOMLES, the Information System on International Level Standards. It's stated that Nigeria has ratified 44 conventions of ILO, and 30 are in force, and while 4 conventions have been denounced. And then 8 instruments are abrogated, and none have been ratified by Nigeria in the past 12 months. So against that backdrop, I would like to ask Mayowa, to explain to us what the steps are, what steps are involved in the domestication of a convention in Nigeria. And maybe you can also throw more light on how or whether if we have any legal and institutional obstacles, militating against the effective domestication of all these ILO convention and standards. Maya, over to you, please.
Thank you, Noso. Good afternoon, everyone. Good morning, good afternoon, good evening, wherever you are. Noso, thank you for that question. So the process of ratification of some of these ILO recommendations or conventions in Nigeria. Can you hear me?
Yes, we can hear you. Yeah.
It includes, the first steps is that Nigeria must sign that convention, which it has for most of the majority of the conventions. Nigeria is a signatory to. But apart from being a signatory, Nigeria needs to ratify. Nigeria needs to ratify all the conventions. That means that it needs to sign it. It needs to now pass it into a law to make it binding in Nigeria, and not only passing it to a law, it also needs to incorporate it into a law in Nigeria. So it's not just about ratification, also an incorporation into our law. That will mean it has to pass through the National Assembly and have the presidential assent and become a law in Nigeria. Then apart from it becoming a law, the next step is implementation. And on this implementation, I think the NIC, that's National Industrial Court, have done a lot by virtue of the third alteration, because the third alteration that allows the NIC to use the international best practice. That has done a lot in the implementation of the ILO conventions. Then apart from the implementations, we also, just like Tama has mentioned in our opening address, we also need to report what Nigeria is doing in terms of the convention. We need to report it regularly to the convention. Then I think the second leg of the question that Noso is asking me is, what are the obstacles, right?
Institutional or legal obstacles against this effective implementation or domestication of these conventions.
So the major obstacle that we have in Nigeria against the implementation of some of these ILO conventions is some of our culture. For example, when you look at discrimination against women, some part of Nigeria is still a little bit patriarchal, and you will see that women, the rights of women are just coming up in those environments. Like, for example, in the north, but I think Nigeria has done a lot. They have implemented some of these acts. They have implemented some of these acts, and has also made a lot of legislations to ensure that these conventions are part of our law. Thank you.
Okay, thank you, Maya, for that. We will still talk more on that, but I have to quickly go back to our lead speaker to ask her to give us some insight into some of these issues that we have raised, in this discussion. And I will have to get back to you, Tama. And the issue of occupational segregation and classification, how do you think it has affected the efforts to eliminate discrimination from the workplace globally? And while answering this question, I would also want you to give us some insight, maybe following reports of committee of experts on how Nigeria have fared globally, or what appears to be the perception of Nigeria in this regard. But the basic question will be, to tell us in what ways that occupational segregation, as we understand it, and classification, how it affects the efforts of to eliminate discrimination at workplace from a global standard. Tamara, please.
Yes, thank you for this question. It's really, really important. And I would say that, of course, what you've just mentioned, the occupational segregation and classification, of course, affects in a lot of ways to eliminate the discrimination for the workplace. And it's kind of global perspective, from the global perspective, and a lot of countries share these problems. So the general roots, I would like to stress an emphasis on the general roots that causes of occupational segregation. And I would kind of classify like the factors that affects it. It's a social, it's economic, it's cultural, and it's historical. So the general root causes of occupational segregation are social, cultural, economic, and historical. They determine both the extent, I would say, and patterns of occupational segregation around the world. And the factors constitutes also the direct, indirect obstacles for women and the marginalized group of people. And the discriminatory approach comes from starting from the entry to the work and during the work, in work, causes occupational segregation. I would say directly and indirectly. It means that some women are excluded from the labor market. Direct form of discrimination tends to favor men in recruitment, in provision setting, in promotion, in type of contract, in pay level, and etc. and etc. So let me talk a little bit about the opportunities and also the problems that that causes the occupational segregation and classification. So it of course the limits opportunities. So when certain occupations are dominated, for example, by specific demographic groups due to historical biases or discriminatory practices, it can limit opportunities for other groups, for women, and it can perpetuate the inequality and make it harder to a group of women or other marginalized group to get access to high paid positions. So the other cause, it's of course that occupational segregation often leads to wage disparities, of course, where jobs predominantly held by women or other groups of minority groups are undervalued and paid less to similar positions dominated by men or majority groups. And this contributes to perpetuation of economic equality and reinforces, of course, the discriminatory practices. I would also stress your emphasis on career advancement, the so-called glass ceiling issue, that barriers in promotion, career development facing women are frequent, as we know, referred as a glass ceiling. So segregation within occupation can create barriers to advancement for individuals from underrepresented groups, limited access to mentorship, to networking opportunities, career developments, and of course, programs can hinder their ability to progress in their careers and, of course, take a leadership position. I would also make one more cause as the reinforcement of stereotypes that occupational segregation and classification can reinforce, and of course it limits the abilities of the minority groups and women to advance because of the family responsibilities, because of the other factors that I've mentioned, and of course underrepresentation in decision making roles. That's also one of the root causes that we all know that invisible barriers and bias keep women and minority groups from opportunity to advance in workplaces. So, and the lack of diversity in leadership can perpetuate discriminatory practices and limit the implementation of inclusive policies and practices. And I would say that what needs to be done. So in order to overcome the root causes and to actually ensure equality at workplace and employment occupation. So it's like addressing occupational segregation and classification often requires changes, of course, in the legislation, in the policy levels, promote equal opportunities and diversity in the workplace. So we can see from the recommendations that I previously mentioned, that Monica referred several times about the supervisory mechanisms that provide specific recommendations to the countries to promote equality. So they, of course, in the majority of the countries face the problems with proper legislation. But when once the legislation is in progress, is in place, then it needs, of course, to be implemented in an efficient way. And it's also important to have a policy level instructions at workplaces. So that's another issue that needs to be kind of achieved while kind of addressing the root causes. And of course, I would also like to talk about the global perspectives. So the challenges of addressing occupational segregation and classification vary across different regions, of course, and cultures. So strategies for combating discrimination in the workplace needs to consider, of course, local context. It needs to be adjusted to the local context. Cultural norms, of course, historical factors that influence patterns of segregation and inequality. So when we talk about the segregation and classification, addressing these issues is essential for, of course, advancing efforts to eliminate discrimination from the workplace globally. And this requires multi-phased approach that includes policy intervention, cultural shifts, and consolidated efforts to promote diversity, equality, inclusion in all aspects of employment. So which means that in the one hand, it is important to know the root causes according to the cultural diversity, historical background of the country, and then to have in place the proper legislation to actually meet the minimum standards of equality, and then to implement it in the country at national level properly, with the policy documents, with the institutions that addresses the issue, and of course to do a lot of with the social partners and the government with the social partners, and of course unions role here is really kind of core to raise awareness about the equality and the non-discrimination, and of course to address all those root causes to overcome all the challenges, economic, cultural, historical, that hinders to achieve equality at workplace. And most importantly, and that will be the last sentence from my side, so everything needs to be at country level, so to calculated statistically to see and to analyze what's the root causes depending on the country specificity that causes the inequalities, and address it in a proper way, that it is country related, that it is culture related, and to consider historical background too. So thank you.
Thank you, Tamara. Thank you for that great insight. And I'll quickly go back to Mr. Wilson, and I will ask you a very key and fundamental question, and it's going to be double-barreled. I would want you, sir, to comment on what you believe or what you think is the extent of employee, the awareness on the part of employers in Nigeria on their obligations to refrain from discrimination as required both under the Nigerian Constitution, Section 42, and other sections, and under the ILO Convention 100 and C111. Do you think that Nigerian employers are aware or alive to their obligations in this regard? And then the second question, which I would like you to compress, as much as you can do, is a follow-on on what you had answered earlier on how the National Industrial Code of Nigeria, how it has fared in its role in addressing complaints of discrimination within the workplace. Thank you very much, Senior Advocate.
Thank you very much, so Mr. Moderator. Okay, so I think the first question to ask is there an obligation to comply with C100, Convention 100, and Convention 111? That's where the conversation should start. I can tell you for free that majority of employers in Nigeria are not aware that there is such an obligation. And the reason why you and we are aware is because we are practitioners in this field. Let me explain, just expatiate on this. When you have a statute that makes specific provisions for employment, then employers feel obliged to comply with that statute. As we speak, there is no specific statute relating to discrimination, relating to wage parity in Nigeria. There is no specific legislation. I'm aware that the government has put in some bills or is putting together some bills. One of them I understand is the Labor Standards Bill, which, as I understand it, is still undergoing drafting at the level of the Federal Ministry of Labor. No, Federal Ministry of Justice. So that is one leg. There is also a second bill that is also supposed to deal with the issue of discrimination. But they haven't come out. They haven't quite made it to the limelight. And so what now happens is that we are dealing with just the provisions of the third alteration to the Constitution. When I spoke earlier, I mentioned that the Constitution only mentions in Section 44 provisions relating to discrimination, but none of those rights or none of those protections relates to employment or relates to wages. I am aware that in the Nigerian Constitution, for the benefits of Tama and Monica, in the Nigerian Constitution, there is a chapter in the Constitution we call Chapter 2, which makes provisions for certain aspirations of what the government expects the country to be. And in that chapter, you have economic rights, you have social rights, you have workers' rights, you have rights that you can interpret to include rights relating to discrimination in the workplace or wage discrimination. But that section of the law has been held by the courts not to be enforceable, so it's aspirational. Now, what that means is that it is the third alteration only that we have to deal with the issue that we are talking about. And the third alteration itself, the way it is worded, it doesn't mention the employer. Rather, what it does is to confer jurisdiction on the court to deal with matters that relate to discrimination. So in the real world, what happens is that an infringement would have occurred, and then the case will be taken to court, and then the claimant will make a case that my rights have been infringed, and my rights are based on Convention 100 or Convention 111. And then the court will interpret the convention and apply the convention. Only then will that right become enforceable. So until the court has made an interpretation and application of the convention, it is almost as good as not applicable. Because as you know, the parties to the convention are state parties. While the convention itself is expressed in the manner suggesting that the state parties are supposed to make this applicable to employers in their countries, Nigerian law requires that the convention itself should be domesticated. That is Section 12 of our Constitution. Now, to get around Section 12 of the Constitution, the third alteration has said the National Industrial Court can apply those conventions that Nigeria has ratified. And then fortunately for us, that includes Convention 100 and Convention 111. But the effect of that is lack of awareness, because employers don't go around reading cases. So if you take the broad spectrum of employers, majority of the employers in Nigeria are not multinationals. They are not best practice companies. They are ordinary companies. And so there is no motivation, no incentive to want to know what is going on in the legal space until a case occurs that affects them personally. So if I were to rate the level of awareness and compliance by employers, I would say it is about 2 out of 10%, 2 over 10, and it's really that poor. And hate to say, but there's still, I mean, I like to look at the glass to be half full than half empty. And I believe that the third alteration has provided us with opportunity for us to bridge that gap. If you look at the cases that have come outside of the National Industrial Court, only few cases relates to Convention 100 and Convention 111. As a matter of fact, to my knowledge, I've only seen about a handful of cases relating to Convention 111. I'll mention a few of them as I speak. Majority of the cases relate to other conventions that are more popular than Convention 111 and Convention C100. I was asked to speak about what the National Industrial Court has done, how the National Industrial Court has fared in its role in addressing complaints of discrimination within the workplace. Before I go there, let me just say this on the level of compliance of employers. I've had occasion to advise a lot of employers and to carry out investigations relating to complaints of discrimination. And so the first thing I find is a lot of employers don't have even a manual or a handbook or a policy, a well-defined policy, anti-discriminatory policy. And those who have, it's just a document on the shelf. The implementation is appalling. And so I find during those investigations that whereas both employer and employee are aware that they have a handbook for those who have, nobody, they pay lip service to this. Nobody pays attention to its provisions. And that is the scenario that we find ourselves. Now, concerning the National Industrial Court, I mean, I must commend the National Industrial Court. In the last 10 years, I should say, the court has been very proactive and very aggressive in its implementation of international conventions. And one of the ways that it has done this, it introduced its rules of civil procedure in 2017. Now, these rules, one of the things that the rules have done is to provide procedural mechanisms for enforcement of complaints relating to discrimination within the workplace. The first thing that I noticed, Order 14 of the 2017 rules has expanded the scope of grounds for bringing an action relating to discrimination, which is far, far beyond the scope provided in Section 42 of the 1999 Constitution. So what this order has done is to gather all the relevant conventions, especially C100, C111, and bring the grounds of discrimination under the rules, so that it now becomes easy for a claimant who wants to launch an action on the basis of discrimination. The grounds are long. They include ancestry, religion, gender, marital status, family situation, genetic heritage, ethnic origin, political or geological convictions, union affiliations, tribe, handicap or disability, health, pregnancy, and any other ground. The any other ground is an omnibus ground that any of these grounds mentioned earlier, if it doesn't cover, you can still come under the omnibus ground. Then also the rules have also tried to define sexual harassment, which is one of the discriminatory acts. It has now identified physical conduct, sexual harassment by way of physical conduct, sexual harassment in the form of verbal form, sexual harassment in non-verbal form. A lot of people may not understand, and this came out in the investigations that I did for some organizations. They were not aware. A lot of organizations felt that sexual harassment relates to physical acts, but they were surprised to find that it also relates to verbal, which is suggestions, unwelcome innuendos, suggestions or hints of a sexual nature, sexual advances, and all of that, and non-verbal, such as gestures, exposures, and unwelcome display of sexually explicit pictures and objects. And then, of course, the one that is really innocuous, which is the quid pro quo harassment, where to get something, you need to give something. And so a lot of the cases that has come out of the National Industrial Court relating to sexual harassment are quid pro quo harassment. But what these rules have done is to properly identify them and makes it a head of claim that you can come under. Now, as I mentioned, the court also has considered itself to be a court where it ensures that, according to the court, international labor standards are measured according to the conduct of the employer. So the court always looks at the conduct of the employer and tries to determine if they measure up to international best practices, if they measure up to international labor standards. And where they are found wanting, the court will be quick to intervene and in appropriate cases award damages. I think the most popular case that has come out of the court is the case of AJK against Maduka, AJK Maduka against Microsoft. And this was a case of sexual harassment. And in this case, the employee, a female employee, was subject to all forms of sexual harassment, which, according to the employee, led to the termination of her employment. The sexual harassments were carried out by the country manager of Microsoft, and according to her, the termination of her employment was a retaliatory action and discriminatory action aimed at her because she refused the sexual advances of the country manager. And the court was So this court, the National Industrial Court, applied Convention 111 and also applied the CEDAW Convention, as well as the African Charter on Human and People's Rights and Section 42 of the Nigerian Constitution, to hold that sexual discrimination had occurred, and it pronounced that sexual harassment is a form of discrimination based on gender. And so the termination of the employment of the applicant, because she refused to succumb to sexual harassment from the country manager, constituted acts of retaliation and gender discrimination. And damages were awarded, and which was really commendable. The other one, the most recent one also, is the case of a pastor Mrs. Abimbola Patricia Yakubu against Financial Reporting Council of Nigeria. This was also dealt with by the National Industrial Court. The claimant claimed damages for serial acts of sexual harassment, sexual advances, and seduction of the claimant by her boss, who was the second defendant in the case. According to her, there were incessant, seductive, infidel, and sensuous compliments and gestures, unnecessary harassment from the second defendant, even when she was pregnant for her baby. And so the court again applied these conventions and handed down damages of 5 million naira. Now, I should be quick to mention a caveat here that these conventions, they are not a golden bullet. In other words, by bringing your case under these conventions, it doesn't guarantee you that the cases will be successful. The cases also have to go through, because Nigeria operates an adversarial judicial system. So the cases have to go through the process of trial, evidence, leading of evidence, and proving of the cases. So there are some cases that I've handled on behalf of employers, unfortunately, where the employee's claim was unsuccessful because they were unable to establish their claims. So it means that even from the perspective of an employee, you need to understand how these conventions work. You need to understand how to frame your case under these conventions for it to be applicable to you. And recently, we had a judgment in which the claimant had brought an action under the Fundamental Rights Enforcement Procedure Rules for the benefit of Tama and Monica. So the Fundamental Rights Enforcement Procedure Rules was available under the 1999 Constitution. So if you claim that your rights you've been discriminated against, your fundamental rights have been infringed, the Fundamental Rights Enforcement Procedure Rules provides the procedural mechanism for enforcing those rights. And so she brought this claim. Even the case of AJK Maduka against Microsoft was also brought under the Fundamental Rights Enforcement Procedure Rules, as I'm aware. So in this particular case that I'm talking about, the employee complained. So this wasn't discrimination of a sexual nature, but it was discrimination based on gender. And the employee contended that she was bullied and harassed, and she was constantly threatened and treated unfairly, which made the workplace abusive and unsafe for her. And so her termination was based on these factors. And so she went to court to ask the court to declare that the acts of the employer constituted an infringement of her rights a right to be protected, a right to human dignity and freedom from discrimination as guaranteed by the Constitution, the African Charter, and the conventions. And unfortunately for her, well, the court said she was unable to prove her case, and therefore her rights were not infringed upon. However, the court still granted her judgment based on wrongful termination of employment under another convention of the ILO, the ILO Termination of Employment Convention 158. So it wasn't a total loss for her. So to summarize, it's clear that in appropriate cases, so the courts, the national industrial courts are ready to enforce any breach of fundamental rights or any breach of the conventions. But the claimant has a duty and obligation to set up his case in a way that it will be successful. Thank you.
Thank you very much, Mr. Wilson, for taking us on this journey in terms of application of these conventions by the court and how employers have fared in recognizing their obligations. Ladies and gentlemen, we had planned that this program will last for an hour and a half, but given the topical nature of the issues surrounding this webinar, we seem to be overshot the time allocated. So we'll try and wrap up as fast as possible. But before we go to the question and answer, which we can only take maybe 2 or 3 questions, I would like to ask Monica to just quickly tell us if there are any exceptions to the principle of equal pay for equal work of equal value. And then I will also, after that, Maya, you will just give us your thoughts on what you propose that government should do, to implement, or what government should do or implement to address discrimination in employment and occupation within the workplace. So please, Monica, can you quickly tell us if there are any exceptions to the principle of equal pay for equal work of equal value, or is it an absolute principle that admits of no exceptions? Thank you.
Thank you so much. No, of course, no, it's not. There is no exceptions, but it's clear and it's important to do this job evaluation process, right? With the tool that we were described, that is also mentioned in the recommendation 19, which provide more guidance on this. And also in order to avoid any possible exception, because we're talking about fundamental rights in terms of equal pay, it's clear, and I want to highlight because, after the presentation on judicial cases, which really super interesting. I would like to hear more about that. It's incredible. I mean, of course, when there is no possibility or determination of a contract of the employment relationship is based on discrimination, as one of the cases where I mentioned, we go to the judicial system and we appeal for them to restate the situation. But before that, there's a possibility to prevent this discrimination to occur and also to be sure that the principle of equal pay for equal work fully be applied. And that's why, and I know that probably I don't have much time, I have more things to say, but maybe for next time, but I want to give the message, the key role of the social partner, the key role of the unions, negotiating through collective bargaining, the possibility to establish a job evaluation process. So based on the job evaluation process, we will realize actually that there is no need to have exceptions, because this is a fundamental right, and if 2 persons are doing the same job in terms of value, they should be also receive fair payment. So it's also about social justice.
Thank you very much. Thank you very much. Job evaluation is key, and then the role of a union, in collective bargaining and making sure that these principles of international best practices are thrown in our workplace. Thank you very much, Monica, for that. Maya, over to you, please. Can you just, under 2 minutes or 1 minute, tell us how you think that governments across the globe, but particularly Nigerian government, where we have, our jurisdiction, what measures they can put in place, to address the issue of discrimination and employment in occupation?
Thank you, Noso. So what the government can put in place, which they have started doing, one of the things they need to do is to enact more anti-discriminationary law. Can you hear me? More anti-discriminationary laws. For example, in Nigeria today, we have the HIV and AIDS anti-discrimination law. We have the National Work Policy on HIV and AIDS. We have discrimination against persons with disabilities. We have the pronouncements on sexual harassment, which Leonard San already mentioned the case of AGK. We also have the judicial pronouncements on several laws. For example, the Nigerian Police Act has a particular clause that provides for the dismissal of unmarried pregnant women in the police force. And recently, the court made a pronouncement over the case of Omolola Olajide and the Nigerian police, and said that the dismissal of the claimant because she was pregnant was discriminatory. Yes. So we need more of this in Nigeria. Also, there are also several cases that have made some of these laws, that have pronounced some of these laws. But we need the country to specifically make laws that is stating the conventions, and also pronouncing punishment for infringing on such laws. For example, where you say if you discriminate against a woman, the company will be made to pay an amount like 10 billion. Everybody will know that, oh, my company is at a financial risk. So they will ensure that those discriminations are lowered in their environment. Also, we also need training. We need constant training in our organizations, on the TV, to tell people about the existence of this law and how they can enforce their own rights within their space. So, for example, as a woman, if somebody comes to meet me and says things that I feel is discriminatory, I'm enjoying to tell him that is discriminatory and I don't like it. And if he doesn't withdraw it, there should be reporting authorities, reporting lines, and the trade unions should be looking at that when they go to check out the policies, the human capital policies in the companies that they oversee. I just have 2 minutes. Thank you.
Thank you, Mayowa. Thank you. I mean, against the backdrop of what you have said, I remember one of the cases I handled earlier in my practice as an employment and labor lawyer. It involves a young woman who was hired by a commercial bank in Nigeria, on a fixed term employment for 2 years, definitely 2 years. So 2 weeks into her employment, the bank conducted a test and it was discovered that she was pregnant. So without any notice, she was just quietly terminated. And so she contacted us and we wrote to the bank. So before we went to court, I mean, I'm glad to report that the case was settled out of court. As a matter of fact, they paid 90% of what she would have earned in that 2 years. That was what we accepted as settlement, for us not to take an action, against the company. So I think it's about people speaking up, because there are a lot of these cases which are swept under the carpet. Employees are scared, are afraid of victimization, which is real. Employees are scared of fake redundancy, because that's also a form of punishment that could be exacted on employees who tend to stand on their right. But at the end of the day, just like Monica has stated, labor unions, stakeholders, employment and labor lawyers, we all have a role to play to ensure that these things don't just end up as theories or as laws in our books, but that they are transmitted and translated in action by all concerned. Ladies and gentlemen, thank you for your patience. I think we can take 1 or 2 questions from the audience at this juncture before we have the closing remarks by one of our members, Omano Blessing Omahumi. So if anyone has a question, maybe you can raise your hand and the admin can unmute the person to ask his or her question. Do we have any question from the floor? Any questions, please? Okay, in the absence of that, I will, starting from
There's
Tamar.
a question.
Okay, there's a question. Okay, admin, please, can you admit mute the person who wants to ask the question?
Okay, good afternoon. Can you hear me now?
Yes, please tell us your name and just go straight to the point of your question, please.
Okay, thank you. My name is Max Kongbe. So I want to ask, the experience of Tamar or any of the other speakers, and of course the Leonard Silk as well. What is the experience internationally in terms of the quantum of damages to award, for instance, in a case of discrimination that has been established? And I'm asking this from the viewpoint that the industrial court in Nigeria at a point made it a principle to actually award quite significant damage, sometimes 2 years gross salary, sometimes 3 years gross salary, and we've seen a pushback from the Court of Appeal. So I just want to know, if the experience from other countries is the same, and what we should expect, or what should be the reasonable compensation the court should award where it has been established that there's a discrimination. Thank you.
Come over to you. Just take it as it comes.
Yes, thank you for the question. So it's really interesting for me as a practicing lawyer. So yeah, I had the issue in my country too, while litigating the cases on discrimination. And I would also agree with Precious that said that the courts are kind of, when it comes to discrimination case, so they try to establish all the violations of labor rights related violations, but not the discrimination. The courts in the countries like my country and in the region, they're kind of reluctant, resistant to establish the fact of discrimination. But when the claimant and the complainer kind of files the complaint on workplace discrimination, so there is two ways to compensate the damage made. So it's material damage, pecuniary damage, and non-pecuniary moral damages. So, and it's up to the complaint to decide what's the moral damage, but material damage, like pecuniary damage, is calculated based on the actual damage that that person received. For example, the bills from the doctors if the person needed, or the other statements, psychologist consultation and everything. That counts as a material damage. But the moral damage is not like really in the law. So it's how person assumes that was subjected to the discrimination. What's the cost? They determine it themselves, but it's not much in case of my country. So although we claim the compensation in amount of 1 or 2 years of gross salaries, as you rightly mentioned in your case, so but the court first tries to settle the case when it comes to discrimination issues. So they push the complainants and the respondent party to settle the case and to conduct friendly settlement and sign this document. But if it's still, there is like really very rare cases when court made the decision, and the compensation for moral damage is really low, not much, even less than a 1 year compensation. But it's well, if we calculate it in my country's perspective, it's like $100 for the last case I've heard. But yes, it's I do know that it's a real, but this one was very kind of precedental case that actually brought the liability for the moral damages because of the discrimination. So it's we need to work as lawyers. We need to work on it. So first, to try court to make decision to actually make the good reasonings on the case, and to claim the discrimination, and eventually maybe we'll get the decent amount of the compensation. But at least for now, from my country's perspective and the regional coverage, I would say that even establishing the fact of discrimination, and even kind of granting the small amount for moral damage, so it also counts as a success. Thanks. But we need more, of course.
Do we have another question before we ask the panelists to give us their final statement for the day? Any other question from the audience? Yes.
Yes, please. Good evening, everyone. My name is
Good evening.
Moses. Okay. So I want to ask, is maternity leave and maternity leave allowance a form of discrimination against men? If it's an affirmative, how do you mitigate that? How do you reduce that if it's a form of discrimination against men? Thank you.
Who is your question directed to? Which of the panelists would you like to?
To the Leonard Silk.
Leonard Silk. Oh, okay. Mr. Wilson, senior advocate, please. Okay.
Well, I thought the question would be direct at Tama because they have a more defined discrimination laws.
Oh, okay. Well, yeah, both of you can take care of that.
Okay. So speaking of paternity leave, unless it's in your contract of employment, then there is no, I'm not aware of any law that grants paternity leave. If I miss it, please, somebody can draw my attention to it. But if it's in your contract of employment, obviously you're entitled to it. And then if you're not granted, then you should claim for it. I think that's the short answer to that.
Tama, do you, Monica?
I'm so sorry, I missed the question. So because I don't know, but the sound comes, the line is really poor. So, and I missed the question. So what was the question? So I've heard about the maternity
protection. Can you hear me now?
Yeah.
Okay, so my question is maternity leave and maternity leave allowance a form of discrimination against men? If so, how do you mitigate that? Thank you.
If maternity leave allows...
Did you get the question now?
Sorry, I've heard that the maternity leave allow us to what?
Let me explain to Tama. So in Nigeria, women are entitled to maternity leave allowance. So they're entitled to maternity leave and they are paid allowance and maternity leave. Now, some companies grant paternity leave. So his question is, not paying maternity leave or paternity leave to men employees, is that discriminatory? You're to the female employees, you're not paying to the men. Is that discriminatory?
Yeah, so okay. So it's kind of not kind of a right answer, like the clear, I cannot now provide the clear answer on that, whether it's discriminatory or not, but it also depends on the context. So if there is a legislation provision that grants paternity or maternity leave, and if it is not fulfilled, the obligation from the employer, so then it needs to be considered whether this was the treatment toward one person or the issue overall. When it comes to discrimination, it needs to be unequal treatment, but this unequal treatment should not have legitimate aim. So this is the form of discrimination. So you need to be discriminated against certain group of people. So if there is an issue, if you are discriminated, someone gets it and someone does not get it because of some signs of discrimination. Maybe it can be sex, religion, ethnicity, other signs of discriminations. So if it is not objectively justified, so then it is a discrimination. But if there is other approaches on that, and employer just does not pay the allowances for maternity, paternity, and it is the kind of well-established practice toward everyone, so this is the breach of the labor rights, but not the discrimination. So it's a little bit, so we can talk about this more, but maybe another time. So it needs to meet the discrimination ground to be the
Thank you very much. Thank you very much, Tama. I mean, unfortunately we wouldn't have time for further questions, but just to wrap it up, I would like in this order, Tama, Leonard Silk, and Monica, just to give us your final thoughts, but try and narrow it down to this issue. Or, what would you say is the situation in your country or region regarding equal remuneration. Just summarize and tell us if you see improvements in the practical treatment of workers, as a result of the requirements of this convention. Tell us what you feel is the situation as we have it, and then what prospects do you see in this regard? Just under 1 minute so we can wrap up.
Yes.
Over to you. Yes.
Yeah, thank you so much for having me here. So, and for sharing my experience, so for giving me the opportunity to share my experience. As for the non-discrimination provisions and the equal pay for work of equal value, so I would say that in the regions, the countries try to put in place the legislative provisions on it. Sometimes it is a kind of a work of equal value. Sometimes it's equal work for men and women. So, but there is no indication on work of equal value. But in some cases, countries does not have methodology to measure what's the work of equal value. So in this case, in our countries, there is a recommendation from the ILO supervisory mechanism to define the methodology of work of equal value, and then to try to put it in practice. So, and also there is a recommendation to establish the supervisory mechanism, the effective, efficient mechanism that monitors the implementation of already existing regulations. So in most of the countries in my region, it's judiciary, the courts, it's sometimes labor inspection, and sometimes it's public defender's office. But the boundaries between those institutions needs to be cleared up. So sometimes it's a little bit of messy situation, and people are confused to whom to apply and what they can get out of their complaint. So, and that needs to be settled on non-discrimination provisions too. So, and the policies and regulations, sometimes there are policies at the workplace level, sometimes there is not. But I would also, and lastly, I would also emphasize the importance of collective agreements and collective bargaining toward the discrimination issues. So countries try to add non-discrimination provisions to their collective bargaining and collective agreements, but it is not common. So there is important to have in place the legislation, of course, and policy level instructions, but it's also from our side, from unionist side and civil societies and stakeholder side, it's important to raise the issue in collective bargaining too, and to promote workers' rights protection, non-discrimination provisions under the collective bargaining. I think that should be the next steps, along with others, of course.
Thank you very much. Thank you very much for those closing remarks. Mr. Wilson, Senior Advocate of Nigeria, please can you just give us your insight?
Okay, just to close, I think it's clear from Nigeria's report to the Committee of Standards, the ILO committee, that there is still work to be done. And I believe that if these things are done, we will increase our level of compliance and implementation. I believe that if the Labor Standards Bill finds the light of the day and the Gender and Equal Opportunities Bill, if they come out of the wherever they are and they become law, it will open up the field. Because in my experience, I haven't come across a case dealing with equal pay for equal work of the same value. It's because it's difficult to prove and establish. It's easier to establish a case of sexual discrimination because you're dealing with acts, you're dealing with conduct, you're dealing with communications. But when it comes to equal pay for equal work and all of that, equal opportunities, then it really becomes very difficult. So I believe that in having those laws in place will provide the statutory enablement for employees to feel protected in that regard. Thank you very much.
Thank you very much. Thank you very much, Benelson. Monica, please, just under 1 minute. What are your final thoughts in this regard?
I think Monica left.
Apologized and left when she had another meeting.
Oh, okay, all right. So at this juncture, I will like to invite one of our members in Employment and Labor Lawyers Association of Nigeria, Omono Blessing Omahomi, who will just give some kind of vote of thanks to appreciate our panelists for taking out time from their very busy schedules to come and give us the best that they have in this very specialized area of the law. So, Omono, if you are on, can you just wrap it up for us? Omono, are you there?
Good evening. Can you hear me now? Sorry,
Yes.
My mic was muted. Good evening, everyone. Good evening. Thank you so much. Thank you on behalf of the Employment and Labor Lawyers Association of Nigeria. We want to thank the erudite speakers. As you know, this webinar is International Labor Standard Webinar Series organized by ELAND and the International Lawyers Assisting Workers Network, and also in collaboration with the African Labor Law Society. So on behalf of these societies, we want to say thank you to the speakers. Tama, thank you very much for bringing your own perspective from your region. Monica, she's not here, but we also say special thank you to her. Ade Mayowa, our own Mayowa, thank you so much. The learned Mr. Wilson, SCN, thank you, and thank you for giving us those examples, the cases. I'm sure Tamara was happy to hear some of the Nigerian cases. So we thank you. We thank you so much. And for the audience, I see we still have many people. So this is 3 minutes past 5, and they are still with us. So that shows that it was very interesting, insightful, and educative. I know a lot of people have learned. So we now have to try to implement the Convention C100 and Convention 111. Discrimination, it's out there. So let's see how we can also educate people around us so that we can have more of these cases. Let's test this in court and see how it goes. So I wish everyone a lovely evening and a beautiful weekend. Thank you very much.
Thank you very much. Very amiable Omono. And on this note, and we want to thank the panelists once again, and also thank the audience for their patience. Just like Omono said, that people are still signed on after more than 2 hours, and which underscores the interest, the growing interest that lawyers have for employment in Nigeria. And that goes without saying, because we have a National Industrial Court of Nigeria, which is dedicated just for labor and employment matters. That says a lot, so that growing trend and that growing commitment to imbibe the principles of international best practice is growing. And Employment and Labor Association of Nigeria, we are happy for this international collaboration. We can see that employment law is largely influenced by international conventions, and that underscores our desire to extend hands of fellowship across borders. So we thank our panelists and our very own senior advocates. God bless you all for taking out your precious time. To our audience, we wish you a very happy weekend. And just like Omono has said, the issues that we have raised today will give rise to a follow-up webinar. I will follow up with the event people to ensure that the event committee of ELAN to ensure that we discuss more on this. Let's raise some salient points. Monica and our lead speaker has actually raised some very german points. So it is hoped that in the nearest future, we will all gather again to discuss this, all designed towards uplifting the standards of employment and labor law in Nigeria and across the borders. Thank you all. And on behalf of the trustees of ELAN, we declare this webinar closed. Have a good evening, ladies and gentlemen. Thank you.
Thank you very much. And I truly hope to see you in person next time.
Thank you.
Thank you so much. Thank you so much. Thank you so much. Yeah.
Thank you. Happy to meet you.
Bye.